Imagine a court built to hold the world's most powerful accountable for genocide, war crimes, and crimes against humanity. A court that sits in The Hague with a mandate to pursue justice across borders of the International Criminal Court. But here's the puzzle. While African leaders, militias, and rebels have stood trial, you will struggle to find a single case against the United States or major European powers. Why is that? Is it just about legal technicalities, or is it about raw power, political deals, and the limits of so-called international justice? In this video, we will be examining why the ICC has never dared to put America or Europe in the dock, and what that reveals about the uneasy balance between law and global power. And to understand this, we need to start at the very beginning, with why the US never joined the ICC in the first place. Let's rewind to 1998, when the world gathered in Rome to draft the treaty that would create the International Criminal Court, the Rome Statute. The idea was simple but ambitious. Establish a permanent court that could prosecute individuals for the gravest crimes, genocide, war crimes, and crimes against humanity, regardless of where they took place. 120 countries voted in favour, but the United States wasn't on board. In fact, it was one of just 7 countries to vote against it, standing alongside China, Iraq, Israel, Libya, Qatar, and Yemen. President Bill Clinton did eventually sign the treaty, but it was more symbolic than substantive. He never sent it to the Senate for ratification, warning that major changes were needed before the US could fully commit. Then came 2002. Under George W. Bush, the US went even further, not just refusing to ratify but actively unsigning the treaty. The administration sent formal notice to the United Nations, declaring that America had no legal obligations to the court and wanted nothing to do with it. Why the strong resistance? It came down to sovereignty and control. US officials feared that American soldiers, diplomats, and leaders.
On this side, we have the prosecutor and his team presenting the case. On the other side, you have the defense. Usually the defendant sits at the last row there. And the witness is underneath the public gallery. This is one of the protective measures so that the public doesn't have a direct eyesight on the witness.
Could one day be prosecuted by an international body they couldn't influence. For Washington, putting American military and intelligence personnel under the jurisdiction of a foreign court was seen as a direct threat to national security and military freedom of action. The US position was clear. No outside authority should have the power to put its citizens on trial. This decision carved out the first and most fundamental barrier. Because the US is not a member of the ICC, the court's jurisdiction doesn't apply to crimes committed on American soil or by American nationals in most circumstances. The only real exception is if alleged crimes occur in a country that is a member of the ICC. That's how US actions in Afghanistan, an ICC member state, almost came under scrutiny years later. But within US borders, the shield is airtight. So before even getting into questions of complementarity or political pressure, the starting point is legal architecture. By never joining the Rome Statute, the US built itself an automatic layer of protection against prosecution at The Hague, a protection no African leader or small state could ever dream of. And that legal shield is where the story of American immunity begins. Here's how the second layer of protection works: the principle of complementarity. The ICC was never designed to be the first stop for justice. It's a court of last resort, stepping in only when national governments are either unwilling or unable to prosecute serious crimes themselves. And this is exactly where powerful states like the US and European nations find cover. Whenever the ICC eyes potential cases involving American personnel, Washington points to its own justice system. The argument is straightforward. We will handle it ourselves. On paper, it makes sense. The United States has a vast military justice structure, the Department of Justice, and congressional oversight. So if an American soldier or intelligence officer is accused of wrongdoing, US courts, not The Hague, should take the lead. But here's where the gap emerges. When the ICC prosecutor examined how America dealt with allegations of detainee abuse during the Afghanistan war, the findings were bleak. Human rights groups and even US government reports revealed that investigations were often narrow and selective. The Department of Justice opened inquiries, but they were limited to cases that went beyond the already brutal, enhanced interrogation techniques authorized at the highest levels. Many alleged victims of CIA torture were never interviewed at all. A 2014 Senate Intelligence Committee report uncovered how the CIA misled the Justice Department about its detention program, concealing key details of torture practices. Human Rights Watch found that accountability efforts largely ignored top-level decisions and avoided pursuing responsibility for the system itself. From the ICC's perspective, this looked less like genuine justice and more like damage control. Europe benefits from the same shield, though its relationship with the ICC is friendlier. Many European nations are strong supporters and funders of the court, but they too rely on complementarity. If a British soldier is accused of war crimes, the UK can simply say, "Our system is dealing with it." And unless there's overwhelming proof of a cover-up, the ICC will step back. This principle creates a double-edged reality. For countries with functioning courts, it acts as a shield, keeping international prosecutors at bay. For weaker states with compromised systems, the ICC moves in. And that uneven application sets the stage for the bigger issue. When law meets raw political power, who actually gets held accountable? When legal arguments aren't enough, raw power does the rest. The moment the ICC even hinted at investigating US actions in Afghanistan, Washington's response was swift and brutal. Under the Trump administration, the pushback escalated to open hostility. The US revoked the visa of ICC prosecutor Fatou Bensouda, slapped visa bans on other ICC staff, and even imposed sanctions against officials of the court. Secretary of State Mike Pompeo went so far as to name individuals, warning that anyone pursuing cases against Americans would face consequences. The message couldn't have been clearer. Investigate us, and you will pay a personal price. This kind of pressure doesn't just intimidate ICC staff, it sends shockwaves through the entire system. Member states that are supposed to cooperate with the court suddenly face the risk of political isolation, economic retaliation, or security fallout if they go against Washington's wishes. For a court that depends heavily on states for enforcement, whether it's gathering evidence, making arrests, or funding operations, that kind of opposition is crippling. Then there's the United Nations Security Council, another arena where power tilts the balance. The Security Council has the authority to refer situations to the ICC, even if the country involved isn't a member. That's how the Darfur crisis in Sudan made its way to The Hague. But here's the catch. The US, along with China, Russia, France, and the UK, holds permanent seats and veto power. If a resolution were ever tabled to refer American actions, or even the actions of close allies like Israel, the veto would kill it instantly. In practice, this means the world's most powerful states operate with a built-in escape route. Contrast that with weaker nations. Lacking the same political clout, they can't shield themselves in the same way. Many of the ICC's high-profile cases have come from Africa, often through referrals from the countries themselves or from Security Council decisions that no major power bothered to veto. It's no coincidence that the defendants most often seen in The Hague come from states without the leverage to fight back. So, when you look at the bigger picture, the pattern is stark. The ICC was created to put justice above politics, but in reality, politics sets the boundaries. And in that world, the powerful walk free, while the powerless face the weight of international law.